I thought we'd have a little refresher about Form 1s and how they're used in the ED period. While this talk is for ED docs, it definitely applies to other physicians. Of course, the Form 1 is under the Mental Health Act, and the usual disclaimer applies. This is FYI, you're responsible for your actions. Please read the actual act. The first question always is to understand if the Mental Health Act is a federal or a provincial statute. It is very much provincial, and you need to know that because if you practice in a different province, you have to be familiar with their Mental Health Act or its equivalent. While the general guidelines are the same, there are important differences and intricacies that you have to be aware of. The Form 1 under the Mental Health Act is merely an application by a physician for psychiatric assessment. It's no more, no less. The only thing that you need to know is that the application for assessment is involuntary. So the patient cannot refuse it, they cannot not come, they cannot not have it. And that is why it is accompanied by what's called a Form 42, which is the notice that you have completed a Form 1. And it is important to understand that it is your responsibility to inform the patient of the fact that you have completed a Form 1 and they are going to undergo an involuntary psychiatric assessment under the Mental Health Act. You need to tell them that in person, plus giving them the Form 42 as a formal notice. So before you fill out a Form 1, there are a few things you need to know. First, it's that only physicians can complete it. So medical students can't, however, residents can. Nurse practitioners can't, no other professional can do it. Form 2 is also an application under the Mental Health Act, but it is completed by a Justice of the Peace. So besides physicians, Justice of the Peace can apply for a psychiatric assessment, and this is done based on someone going to the Justice of the Peace, convincing them that person X requires an involuntary psychiatric assessment, and they will issue a Form 2 order, so the police would bring them to a Schedule 1 psychiatric facility. The physician must have assessed the patient personally, and this is in the Act, so you cannot do it by proxy. Even though we work in teams and get a lot of our information through our nurses who collect a lot of the data, we still have to walk in and assess the patient personally. There is a 7-day time frame for an assessment. So from the time of assessment till the time one can complete a Form 1, we have a 7-day window. If we exceed the 7 days, we cannot complete the form unless we reassess the patient. And if that is not possible, then whoever is concerned about the patient need to go to a Justice of the Peace and apply for a Form 2. Criteria for applying the Mental Health Act and Form 1. It is very important to remember that this is a legal document. It has to be completed diligently because otherwise it is invalid. And it is also important to understand that by completing this document, you are depriving a person of their liberty, and we take that very seriously. And again, that's another reason why you have to be very diligent in completing the form, making sure that it is correct, making sure that it's applied appropriately. Otherwise, it will be invalid. The first part of the form is patient and physician identifiers. They need to be clear and correct to the best way you can. We'd like to have them match the patient identifiers on the front sheet of the chart. There are 2 sections to the Mental Health Act, to the Form 1, the Section A and Section B. We invariably use Section A. Section B is applied for patients of non-consenting capacity. Even patients, with significant psychiatric condition and presentation are presumed to have consenting capacity of some degree over themselves. That is why Part B has a much more difficult test. I'm not going to go through it now, but you can go ahead and read it. But we invariably apply under Section A. The test is called a serious harm test, and it includes 2 parts. The past-present test and the future test. So we need information to say that there is risk in the present or, in the past that made the patient present to the hospital, and that there is a significant risk of harm in the future. At least one of these boxes need to be ticked in both the past, present, and the future test. You do need to complete at least 1 observation under each test, either personal or facts communicated by others. What powers come with a Form 1? And this is very important to understand. The Act is very descriptive. When a Form 1 is completed, there are two parts of sort of powers. The first is the police responsibility. Once a Form 1 is completed, and if the patient is outside a Schedule 1 psychiatric facility, the police have a responsibility under the Act to apprehend the patient and deliver them to a Schedule 1 facility. The exception is they think they require immediate medical attention, which supersedes the psychiatric assessment, and in that case, they will stop at the closest emergency department. And that's how we see patients sometimes arriving in other EDs, as in Welland or Niagara Falls, when in fact neither hospital has been a Schedule 1 facility since 2013. Once the patient arrives in a Schedule 1 facility, the Schedule 1 facility has powers under the Act, and they are three and no more. The first is they are able to detain and restrain the patient. It is important to know that those powers in the Mental Health Act supersede the Patient Restraint Minimization Act. And if you're not familiar with the Patient Restraints Minimization Act in Ontario, I highly encourage you to go read it or read about it and be familiar with it. Detention can be physical and restraint can be both physical and chemical. It also allows you to observe the patient and allows you to examine the patient. And these are the only three powers that you get when a Form 1 is completed. It's also important to know what Form 1 is not. Remember, at all times, the Consent and Capacity Act, the Patient Restraint Minimization Act, in non-formed patient, and common law principles are always in effect. So Form 1 is not only for adults, it can be applied for patients under 18 years of age. Form 1 is not for forcing non-mental health assessment. We see this incorrect use of the Act in the community a fair bit, where it is used for aggressive dementia patients. These are patients who have behavioral issue as part of their medical condition. These are not mental health conditions that require a psychiatric assessment under the Mental Health Act. Form 1 does not give you any extra powers to investigate patients or to treat patients. Principles of consent and capacity, as well as common laws, continue to apply for investigating and treating patients. Also, and this is very important, the Form 1 cannot be used to restrain patients other than for psychiatric assessment. We hear that a lot in hospitals. You get a call from frontline staff about applying a Form 1 because a post-op patient, for example, is delirious. The Mental Health Act does not apply in these situations. These are medical conditions, and if the patient's safety requires restraint, then the Patient Restraint Minimization Act is very descriptive on how the Act and common law principles can be applied. And I encourage you again to go and read that and understand it. The timelines of a Form 1. Most people are familiar with the 72-hour rule. However, the Act is very descriptive again in the time frame within which you can apply the Mental Health Act. There are 7 days between a physician assessing a patient and their ability to sign a Form 1. If it's beyond 7 days, they cannot. And whoever is worried about them needs to go and obtain a Form 2 from a Justice of the Peace. From the time the form is signed till the time the patient is detained in a Schedule 1 facility, it is a 7-day period. And this is where most people make mistakes. This is not 72 hours. This is 7 days from the time the form is signed and the patient is detained at a Schedule 1 facility for psychiatric assessment and observation. These 7 days can include the patient being in the community or being in an interim facility. So if the patient is in another ED outside of St. Catharines here in Niagara, this is within the 7 days, not the 72 hours, because Niagara Falls and Welland are not Schedule 1 facilities. If the patient is admitted to a medical ward or for ICU while they are on a form for medical care, which supersedes their psychiatric care, this is within the 7 days. Reminder that the physical medical hospital, even in St. Catharines, has a different facility number than the psychiatric hospital, which is the Schedule 1 facility. Even though they are housed in the same building, they are two different facilities according to the Ministry of Health. And that is why if you look at the bottom of your Form 1, you will see 3 different times and dates. One for the date and time when the Form 1 was signed. The other one is for the psychiatric facility when the Form 42 has been given. And the third one is also for the psychiatric facility when the detention starts. And while the PDF defaults all these 3 dates and times at the same time, if the detention or the Form 42 has not been given, then the last part should not be signed, and these can be changed manually. From the time the detention starts, there are 72 hours where the powers of the mental health are in effect to, if you remember, detain and restrain, physically and chemically, observe, and examine the patient. By the end of the 72 hours, the patient has either to be released or another form completed by the treating psychiatrist. A small note there, the same physician cannot complete the Form 1 and the Form 3, but this is usually not an issue as Form 1 is completed usually by emerge physicians and the Form 3 is completed by a psychiatrist. Unlike a Form 1, a Form 3 can be appealed, but a Form 1 cannot be, even though the patient still have a right to retain counsel. Let us recap Form 1 for ER docs, vital things to know. Form 1 is a physician's application for involuntary psychiatric assessment under the Mental Health Act. It is no more and no less. You must assess the patient personally. You cannot complete a form on someone you have not assessed in person. You must complete the form diligently. It is a legal document. It's also a legal document that deprives people of their freedom, so it is very important to be diligent in completing the form. You must inform the patient of the fact that they are being detained under the Mental Health Act. You need to give them the formal notice as well, so you need to inform them verbally as well as giving them a formal notice, which is the Form 42. You must be familiar with the 773 time rule, 7 days between assessment and completion of the form, 7 days between completion of the form and detention at a Schedule 1 facility, 72 hours from detention till the expiration of the Form 1, where the patient either has to be released or held under a Form 3. Finally, you have to understand the scope of the Mental Health Act, what it allows you and does not allow you to do. You have to understand when it is applicable. You have to understand that there are other acts in Ontario that come to play, including the Consent and Capacity Act and the Patient Restraint Minimization Act. At all times, the principles of common law continue to apply as we care for our patients. Thank you so much for listening, and I hope you find this useful. Have a great day.